short of a constitutional convention put
Yeah.
forth by 2/3 of the states, which I don't even want to disregard that as exceedingly impossible as it seems. I mean, that's still at least in theory, something that could happen and maybe will happen. Who knows? One day in our lifetime.
Well,
But
I think the problem with 66%, well, right now we have 39% of states who have effectively banned abortion.
right,
There you go. There's your answer. We'll never reach that threshold. I mean, and we were just talking about this off camera. The Missouri Attorney General just came on and said, we are proud based upon our law, because it had an automatic trigger in the event this law is reversed, because this is something that's been brewing for years, that he was proud that they are the first state to eliminate abortion without exception. Without exception.
yeah, I think and I haven't done the deep dive, but I think it's because there were some old carryover laws from pre Roe v. Wade, and now if Roe v. Wade ceases to exist, then those laws theoretically come back into play. But yeah, it's kind of, I don't know, it's unsettling for me, both as a lawyer and a human being.
Yeah.
But when I've read as much as I can, it's a long opinion and probably one that should be read 8 to 10 times before pretending that you really understand what the court is trying to convey. But at the end of the day, what's the name of this? Is it the Dobbs opinion? Is that what it's going to kind of be referred to? Dobbs versus Jackson.
Yeah.
At the end of the day, it's one of these things where, although we're talking about is there a right to an abortion, it really comes down to substantive due process under the 14th Amendment.
Right.
Whether or not there's this inherent right to privacy there or other rights. And, even though the majority opinion authored by Justice Alito has some express carve-out language that we are only addressing the right to abortion, this doesn't impact any of our prior precedents on any other constitutional rights. Then you've got Justice Thomas in a concurring opinion, and Justice Thomas obviously having joined the majority, basically saying, well, we should call into question some of those other opinions. And I think, for those out there that haven't made the connection, the reason Justice Thomas is saying that about things like same-sex marriage and other things is because those rulings upholding the existence of those rights were based on the same substantive idea that the 14th Amendment afforded these things. And so if it doesn't afford abortion, it's, yes, we can read this opinion narrowly, but it's also like a head scratcher to think that when these other rights get challenged, and I'm sure there'll be a wave of litigation about it, how's the majority of the court going to distinguish it at all? Abortion to same-sex marriage. They're two different things, but in a legal sense, they both arise, or they used to, out of the same area of law, out of the same portion of our Constitution. And now it seems for one of them they don't. So it's just I don't know if the writing is on the wall is the right expression, but getting back to this idea of like being able to kind of predict how future legal challenges will come out. We're trial lawyers predominantly. Nobody really knows how a trial is going to come out. You have educated guesses, but you never really know because it's in the hands of jurors who are people of the community. On the appellate side, especially when you get to the higher courts, you have this weird sense where you can almost predict. And so we'll see when and if that happens, but that's what my intuition says.
Yeah, I mean, I think Judge Thomas in his concurring opinion used the words "decidedly erroneous." I think was when he talked about 3 Supreme Court opinions. One was Lawrence, Offerdahl. I think it's not, might not be Offerdahl, but it starts with OF, and then I forget the third one. But the idea was that the access to contraceptives for a married couple was one of them, which seems to me like that shouldn't even be an issue, but I guess it is. The other one was Lawrence. That was the one where essentially the ability to have or perform sexual acts in your home, which was really derived.
Again, a right to privacy, right? Like at the end of the day, it's right to privacy.
And then the other one, and I guess that was in a predominantly same-sex relationship. That was, and then they had the same-sex entitlement to marriage. He said these are decidedly erroneous. They're based on the same due process rights, and that Roe v. Wade was, and that it should be revisited and basically overturned. And I talked about this is because there was one opinion that he did not mention was Virginia versus Loving, or if it's Loving versus Virginia, which was the entitlement to individuals to have interracial marriage, right? I think it was a white man married a black female, or a black female married, a white male. And he didn't mention that case, which again is based upon that same reasoning, and that's because Clarence Thomas is a black man married to a white woman, right?
Well, I'm a white man married to a black woman, and I mean it's deeply in my consciousness, and I'm sure tons of others.
Yeah.
And it begs the question. This is what I was suggesting to you earlier, and your point is a valid one. We're talking about abortion today because that's the decision of today. But at the end of the day, if you just peel back one layer, it really calls into question, is there even a limiting principle if we're going to say that the 14th Amendment doesn't have this inherent right to privacy? So I'm just pulling up, I think it's page 5 of, it's not in a reporter yet, but of the Dobbs decision. And you've got the majority says this: Roe's defenders characterized the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. Doesn't say gay or interracial, just marriage. But abortion is fundamentally different. I basically quoted, except for my little editorializing over marriage. So you've got the majority basically saying, oh, no, abortion is fundamentally different. But as far as I can read the opinion, I don't know how substantively that can be said. If all of those other areas of law, those rights, I'm going to call them rights because I believe that they are, and as of today they are. If those rights all arise or stand on the same foundation, and today a majority of the court just said that foundation is not even a thing. It was never a thing. It was erroneous from day one. Well, then how on earth can you say abortion is fundamentally different? And I don't, if I were a betting man, which I am, but not in this context, I mean, just casually, if I were a betting man, I find it impossible to believe that when these challenges find their way up, that the court's going to be able to meaningfully distinguish them on some fundamental difference. I just don't see it. And it's, for me, like I said, as a human being and as a lawyer and as an American and all these things, and everybody's entitled to their own opinions, and that includes me. It's incredibly disheartening and disappointing. And I have these feelings of fear that I really didn't have before, as the father of 2 young children, as the husband of a black woman in an interracial marriage. All of these things come to my mind, just like, where's the limiting principle here?
Right.
And it's hard to feel the love in a moment like this. And, I'm not trying to be self-involved, but everyone out there has to kind of reconcile these things on an individual basis, right?
It's okay to be self-involved. I mean, these opinions are wide sweeping and affect everyone, right? People use the word slippery slope, right? You always you got to think about, what is this going to do? Is it going to create a slippery slope? It's been created. I mean, this opinion can be applied to run downhill and smash through all those other Supreme Court opinions. Because if you're going to say that this legal application, which upheld Roe v. Wade, is erroneous, then that same application, and it doesn't matter in what context, right? Because I don't think if you're saying that there's some kind of factual dissimilarities between it, there's really not. It's really the legal basis to find that protection afforded in the Constitution. And if that legal basis is wrong, and it's the same basis for a multitude of opinions, the Supreme Court said it's wrong.
Yeah, I mean, they don't just say it's wrong. I mean, here's page 6 of the opinion. This is one sentence. Roe was egregiously wrong from the start, period, end quote.
Yeah.
Those are pretty strong words in any appellate opinion, let alone from our nation's highest court, talking about precedent that's been there for 50 years, talking about a precedent. It's not just like Roe v. Wade exists in a vacuum, right? We had Casey versus Planned Parenthood many years later, modifying the doctrine a little bit, but ultimately affirming the underlying principle. So, for a court today in 2022 to say a case was egregiously decided way back then, but another version of this court not too long ago relative to our history affirmed it. It's just, I don't know, it's a bit of a head scratcher. It's not that the writing wasn't on the wall or that, this is a situation where, I mean, in a truly unique situation where there was like leaked opinions of the leaked draft opinions. So the writing really was on the wall. I don't think it took anyone as a surprise, but it takes me by surprise in terms of the reasoning. just complete evisceration of something that had been there for a long time and used in a variety of contexts to uphold what I'm going to continue to call the right. And so, I mean, it's kind of beyond the scope of this podcast, what's intended, but I mean, my heart goes out to anybody who out there who this opinion like changed their life on an individual level or family level today, literally today, massive changes, or massive hurdles put in someone's way. It's just crazy to me. I don't know. It's,
I mean, look, we
unfortunate,
we're a legal podcast that talks about legal effects, but when big Supreme Court decisions come out, it affects all of us. It's important to talk about, right? Because like the benefit of having a supposed free working society is communication and dialogue and speaking up and protests and all of those things. I mean, that's what's supposed to be fundamentally a backbone of this country, right?
Thanks for checking out the John and Jordan on Justice podcast. If you enjoyed today's content, consider leaving us a review and be sure to subscribe wherever you heard this podcast so you never miss an episode. For more information or to connect with John and Jordan, check out @OnJusticePod on Instagram and Twitter. Or check out Discord for plaintiffattorneys.com to communicate with them and like-minded plaintiff attorneys in a private Discord server. Until next time, this is the John and Jordan on Justice podcast.